Recording in progress.
Good evening, everyone. Welcome to the Plymouth Planning Board meeting for this Wednesday, July 10th, here at the 1820 Courtroom at Plymouth Town Hall, 26 Court Street. It being 7 o'clock and a quorum present, I'm calling this meeting to order. Mr. Grandy will not be present this evening. Pursuant to Chapter 2 of the Acts of 2023, an act relative to extending certain COVID-19 measures adopted during the state of emergency and signed into law on March 29, 2023, this meeting will be conducted via remote and in-person participation. Information and guidelines for remote participation by members of the public may be found on the town's website. Our first order of business tonight are our administrative notes, beginning with our minutes from June 12 of 2024. Do I have any questions, comments, changes from members of the board? Ms. Keene.
Thank you, Mr. Chairman. In looking over the meeting minutes, I believe that it was only Mr. Grandy and myself who were on the board when Carver Landing came to us, I think a total of 3 times. And it says here that the board inquired who maintains the gardens on the second paragraph under West Plymouth Steering Committee. And it says the initial funds for the project came from a donation from the Carver Landing developer. And I think that's a little bit misleading because it sounds philanthropic, but actually the donations came to fulfill an obligation owed by the Carver Landing developer. And so I'd like to correct the meeting minutes so they're representative of what actually happened.
Okay, do you have suggested specific language that you'd like to add?
Well, it says here, a donation from the Carver Landing developer, and I just want to say that it was a donation to fill an obligation, or a donation from the Carver Landing developer to fulfill his obligation, probably obligation to Carver Landing, however you'd like to. Could you show us what that would look like then, Deborah? No?
Not on the fly.
No, okay.
Well,
But I would like that change to be made.
So to fulfill his obligation, what's his obligation?
Well, do you remember he came back 3 times?
Yep.
First, he took out the daycare
Yep.
and put up housing. Then he took out the lodge and put up housing. And that left him with an obligation to the town within his development. And he settled that obligation by a donation to the West Plymouth Steering Committee. It wasn't philanthropic.
So how about donation from Carver Landing to as mitigation for changes in the plan?
That sounds perfect. That's exactly what it was.
okay. Any member have any objection to that? Seeing none, I think that's fine. We'll add that. Anything else from anyone?
Thank you.
Seeing nothing then, do I have a motion with Ms. Keene's change?
Should I make my own motion?
Go ahead.
Motion to change the wording in the meeting minutes
Well-
to reflect,
Well, it's to approve the minutes.
to approve the minutes.
Second.
I have a motion and a second. Any discussion? Seeing none, and all members present here, I'll just call for a vote by raise of hands. All in favor? It is unanimous. There being no covenants, plans, or releases, I'll move next to Form A plans, and we have A 4880 Birdsong, Barefoot Cottage Company, LLC, lot line adjustment, map 77, lots 10-662 through 10-675, S284, S285, S304, and S305. Do we have any questions from the board? Seeing none, I'll entertain a motion.
I'd like to make a motion to approve A4880 Birdsong Barefoot Cottage Company, LLC.
Mr. Donaldson so moves. Do I have a second?
I'll second that.
Ms. Keen seconds. Any discussion?
To just like to correct the language that it's to endorse, not necessarily, we don't approve. We endorse the Form A, so it's approval not required.
Yeah.
Thank you. That is the correct term. Thank you, Mr. Bennett. So I have a motion to endorse and a second. All in favor? It is unanimous. Next on our agenda, we have an appointment to the Cedarville Steering Committee. Patricia Adelman.
Good evening, and thank you for considering my application to the Cedarville Steering Committee. I've lived in Plymouth for about 46 years. I've seen a lot of changes in the village of Cedarville. I've always been very interested in the Cedarville Steering Committee. I think they do a good job of relaying a lot of information to the public, and I would like to be part of that.
That's terrific. Thank you, Ms. Adelman. Questions from the board? Mr. Donaldson.
Hi, good evening. So as a member of the board, what do you see your role is, and what do you think the role of the steering committee is?
Well, developers looking for a special permit, they come before us as well as the planning board. We're only advisory, but I've been to a lot of meetings where businesses come before, and it's a very community feel. The commercial interest wants to make the village very successful. I also would like to work on the Cedarville Steering Committee master plan, and I think it goes right along with the town's master plan. Thank you.
Thank you.
Any other? Mr. Bennett.
Ms. Edelman, I applaud your effort and your willingness to serve. One question on your application that just puzzled me was that you had to have attempted to become a member of the committee for 3 times already?
This is my 3rd time. I was not voted the previous 2 times. The incumbents were voted in, and I went before the select board.
I see. Okay, so there was competition.
Yes.
I see. Okay, that clears it up for me. Thank you. One other question is, your address is in here. I won't mention it to the public, but it seems as though you're not really in Cedarville itself. And forgive my ignorance, I don't know what the boundaries or limits of the Cedarville village are.
There really are no boundaries. It's supposed to be encompassing the commercial district, but my precinct includes Cedarville, and my part of town has no steering committee. I'm hoping that will be addressed with the town's master plan.
I think you make a very good point there, and I'm certainly satisfied with your answer.
Thank you.
Anything else? No. Well, just as a point of order for the board, we have no specific requirement regarding residence for being a member of one of the steering committees. We certainly encourage the members of the steering committee to come from their particular village, but it's actually not a requirement as part of anything. So regardless as to the boundaries of Cedarville, Ms. Adelman's proximity and her knowledge and understanding of the area, I think, more than make up for any other issues that could arise from that.
Thank you.
Seeing nothing further, do I have a motion?
Motion to approve Ms. Pat Edelman for the Cedarville Village Steering Committee.
Do I have a second? Thank you. Mr. Bennett seconds. Any discussion?
Yes, I'd like to just say one thing, if I could, Mr. Chairman.
Certainly.
I just wanted to thank Ms. Adelman for all of her volunteer efforts for this town. For 46 years, you have been a big part of this town, and you just keep on keeping on, and I want to thank you for all of that, all your efforts and all your time.
Thank you. There are many people that contribute as much, if not much more. Thank you.
You're welcome.
I'm going to call the vote now. All in favor, raise your hand. It is unanimous. Thank you very much. Of course, remember to get sworn in, and we look forward to your long tenure on the Cedarville Steering Committee, starting with the meeting next Wednesday.
And can I just, I understand that Jerry Hooker did not reapply, and I just want to commend her for all these years. When I think of Cedarville, I think of Jerry Hooker. I just want to thank her, and thank you.
Thank you, Ms. Adelman. Next on our agenda is ZBA 4130. I'm sorry? Oh, my goodness, you're absolutely right. I am missing the new update. Moving to our next appointment, we have the reappointment for the West Plymouth Steering Committee of Brian Collins. Is Mr. Collins present?
Yes, good evening, I'm here. Can you hear me?
We can. Thank you very much. Proceed, Mr. Collins.
Okay, I've been on the steering committee since 2020. I've enjoyed working with the steering committee. Been involved with multiple projects, the Route 80 sidewalk. We're working now on the Route 44 or Somerset Street sidewalk project, as well as taking lead on the community gardens that we've been placing around West Plymouth, in particular at Federal Furnace and West Elementary School, and just most recently at the West Plymouth Fire Station, the garden that we put in there. So I'm looking forward to continuing those efforts, as well as getting more involved in the master plan. I've noticed that our master plan is dated 2016. It's definitely, I know the town is updating the master plan for the whole town, but looking forward to working on the West Plymouth master plan update as well.
Very good. Thank you very much. Bring it back to the board. Any questions? Ms. Keene.
I just wanted to say that I'm the planning board liaison to the West Plymouth Steering Committee. And we have Brian, with all of his efforts at gardening and making it all happen. I just wanted to thank you for the work that you've been doing, and I will definitely vote for your reappointment.
I appreciate that. Looking forward to setting up many more gardens.
Mm-hmm.
Well, that's greatly appreciated. You certainly made West Plymouth more beautiful by your efforts. Any other questions or comments? Seeing none, I'll entertain a motion.
Motion to approve Brian Collins for a new 3-year term on the West Plymouth Steering Committee.
I have a motion. Do I have a second?
Second.
Mr. Donaldson seconds. Any discussion? Seeing none, call for a vote. All in favor, raise your hand. It is unanimous. Thank you, Mr. Collins. Welcome to another 3 years of hard work.
I'm looking forward to it. Thank you very much.
We next have, our next appointment is for the reappointment of Carol Rapenian on the Plymouth Center Steering Committee. Ms. Rapenian?
Hi, thanks.
Good evening. Welcome.
Thank you.
So why do you want to be reappointed? Go ahead.
Because I was asked. I've started serving as the clerk this past year, and I like being involved and giving back to the community.
There's really no better reason, as far as I'm concerned. Any questions from the board? Seeing none, I'll entertain a motion.
I would like to make a motion to reappoint Carol sorry, I'm not gonna say your last name. I'm gonna butcher it. To the 3-year term.
We have a motion to appoint. Do I have a second?
Second.
Second by Ms. Keen. Any discussion? Seeing none, all in favor, raise your hands. It is unanimous.
Great,
Thank you very much. That concludes our appointments for this evening. Moving next to ZBA 4130, 76 Hillside Drive. This is a post facto special permit required per section 203-9C to expand or alter a pre-existing non-conforming structure to construct front porch, steps, and an addition. The planning board is advisory to the zoning board of appeals on this matter. Do we have someone here for the petitioner? Please come on forward to the microphone. Identify yourselves for the record.
I'm Jean Simpson.
Paul Simpson.
Good evening, welcome. So I'm sure there's something you'd like to tell us about how this all happened and what brings you before us, so please go right ahead.
Sure, it was simple to me. It was about the spring of 2020. My parents were living up in the mountains up in New Hampshire. My father was having dizzy spells and falling, and my mother couldn't pick him up. As her children decided they needed to come live with one of us. The family decided it would be us, so we started to look for a builder, I guess, somebody to help us out, and we got a few recommendations, got some people to come and look, and one man said, yeah, I can do it, let me take some measurements and so on and so forth, and I'll get back to you. And a little bit of time went by, and he came back and he said, this is what I'm able to do. And unbeknownst to me, that was not all it takes. But I didn't know that at the time. We didn't know that. We assumed that he was, and I know assuming is not a great word, but we were assuming that he was doing what builders do on their end to make sure that they can do a project. So he did the project for us. And what else?
He did a drawing and he gave us the specifics, so we gave him a go-ahead, and then a few years later, my daughter and 4 grandchildren moved in, and all of a sudden someone called, 5 more people living in, and we didn't know, we didn't pull permits, we had no clue.
Ignorance is our defense, I guess.
Well, I'll say ignorance is only part. Obviously, reliance is certainly part, and that's not an unreasonable reliance. Let me bring it back to the board. Are there any questions?
So if I could.
Oh,
just-
please, let staff.
So this is Hillside Drive. It's in Ocean Air, southern part of Manomet. I would point out just a couple things. First of all, the DPW has reviewed it. They have no comment, no issues. Also, as we've seen in a couple other cases, the penalty for this is the fines. The permit fees are all doubled for people who do what we would call a late filing. When you look at the site plan, I just think it's important to note that the setback for the structure itself is only 2.3 feet short and 4.3 for the stairs. So it's a pretty minimal setback issue of 2.3 feet for the main structure. I look at these as if the risk is theirs if somebody has an issue with it, but those are pretty minimal. So if we look at this, and if I look at this as if it was coming in today, those are very minimal setbacks, and we would have been supportive if it had been filed on time. So again, it's minimal relief that they're looking for, and we have no objections, recommending that the board approve it.
Thank you, Mr. Hartman. I will bring it back to the board at this point. Any questions for the petitioner? Mr. Bennett.
So as part of this process, did the contractor provide you with proof of insurance or a license or anything like that?
He gave it, I'm pretty sure, it's been a while, I'm pretty sure he showed us his builder's license, insurance, did a contract, and we signed the contract, and then I was working at the time, so I was just paying him every other week. I wasn't paying attention.
Okay, and I guess my other question, and it's probably a moot question, is for staff, is that for a contractor that performs this work without a permit, there's no recourse, is there?
I don't know. I mean, certainly not by the town. If there's recourse from the applicant or the property owner, that would be separate, but the town doesn't have anything, but yeah, no.
I think there probably would be some through the licensing agency that licenses builders, assuming he had a license. You know, I, for one, and this is certainly not a condition or a recommendation, but I would be happy to see if you maybe filed a complaint against his license, because somebody who's doing that shouldn't be allowed to operate. It's a disservice to the public.
Yes. I mean, we're already off 4,000 having surveyed and permits and stuff, so he's costed, so I would like to do that.
No further questions.
Ms. Keen?
So I have a few questions for you. I'm always the one that complains about post factos because it sets a precedent in the town, while yours, let's say transgression, the fact that you didn't come to us for a special permit was really only a small, relief, as Mr. Hartman pointed out. There are others that have come post facto seeking, a greater relief. But, and I don't like those precedents being set, because we're not about to ask you to tear down your addition and your front stairs. But did you get any other bids besides this one bid?
We did.
Two or three other bids.
And they, did they mention the permitting process? Was it part of the contract?
We didn't, the word permit honestly didn't come up.
To anyone, and they were all twice the price.
As I say, yeah, their numbers were higher, so we went with this one. But as I say, I asked, perhaps it was my, anyways, I asked, is this something we can do? You know, and that's where I said he took measurements, went
Yeah.
away, came back.
But you never saw.
So the word permit never came up. I guess I thought it was implied when I said, is this something we can do? That he was giving me the answer, yes, this is something we can do, because I just went and researched that or did whatever it is that a builder does.
Yeah.
I have never had a builder build, so that's,
And do you still live in the home?
yeah.
Yes.
With additional family now that you can?
No.
Oh, okay. All right. I think that's really my only questions. I just wanted to make sure that I get it on the record that we do not endorse post facto permitting on the planning board, and find it really difficult to really, we're chastising the wrong people if we chastise you, is my feeling, and I don't want to do that.
Thank you, Ms. Keen. Mr. Donaldson?
Yes. When did you find out that the new addition was not permitted?
When we got a letter from the town of Plymouth, a certified letter, I think that was December or January.
I think one of our
Just
neighbors
passed.
called because my
but
daughter had
that's
a
what-
problem, and the 4 grandchildren moved in, so it was 5 more people in the house, and all of a sudden there was someone at the house.
We got a letter from the town, and we responded right away and did as much as we could.
And how long have you owned the property?
30 years,
30 years. And the addition was done
2020.
2020?
Yep.
Okay. I did have one other question. So you said currently no one else is living on that,
No,
in that other addition?
correct.
And so what are your, I mean, you don't have to tell me, but is there any other further plans for that property? Eventually, is some other family going to move in? Are you going to
We
claim it
hope
as an
not.
ADU?
We took all the beds out, we changed it, put chairs in there now, and just trying to relax.
It's basically a den
A
now.
whirlwind.
It's nobody's going to be living in there now.
Okay, thank you.
Thank you very much. I think you've answered any questions to my satisfaction that I may have had. I will open this up to public comment. Is there anybody in the audience who wishes to be heard on this matter? Seeing no one, Mr. Hartman, anyone on Zoom wish to be heard on this matter?
So if anyone on Zoom likes to be recognized, speak up. I'm not seeing anyone.
Okay. Seeing no public comment, I will bring it back to the board to entertain a motion.
So, motion to approve the post facto special permit for this couple,
To recommend approval to the ZBA.
to recommend approval to the ZBA.
Do I have a second?
Second.
And Mr. Bennett seconds. Any further discussion? Seeing none, I'll call for.
I'm sorry, Mr. Chair.
Certainly, Mr. Donaldson.
Yeah, I actually want to talk to some questions for Lee in regards to this situation. So this is kind of like what the second one we've dealt with this year, and when it's, and I'm in agreement with my my counterpart in regards to if this happens with the builders themselves. Can we? I mean, is there like a way we can do like a list of like this, of some people that we've seen this happen before, or?
Those would all be questions for the building commissioner. I don't know. I don't
Okay.
know.
All right, thank you.
Okay, thank you, Mr. Donaldson. Any further discussion from the board? Seeing none, I will call for a vote. All in favor of the motion to recommend approval to the ZBA, raise your hand. It is unanimous. We wish you good luck before the ZBA and getting this resolved and behind you.
Thank you.
Next on our agenda, we have site plan review. We have two site plan reviews, and they are actually identified separately but presented together. Is there any issue, Mr. Hartman, with us addressing both of these jointly?
No, not at all. What I'm going to do, with your permission, is I did create a GIS map so you can see where this sits in the airport, because it is a very large area. So, and then we'll go to the presentation.
Okay, and for the record, these are site plan reviews for 218 South Meadow Road and 220 South Meadow Road, which are to demolish existing hangars and construct new hangars at the Plymouth Airport.
So just the admin buildings here, we usually go to these sites. And then I just did this where you have the existing front building,
The back buildings, the small one, yeah. I think he's going to hand those that way. Can reach across.
just to show how this lays out. So this is the whole airport, this is the admin building with the plane games, and this is where it's located. And what I did too is to show the existing buildings in the front here. The new building is a black outline that goes here, behind that building, and then the small building's demolished, and the bigger building goes there. Yeah. No, that stays. So this is going to be actually behind us. So, and I'll mention it. So most of this one gets shielded, but this is the only one that has something.
Good evening, and thank you for having us. My name's Jason Wilson. I'm the one trying to construct the new hangars, 218 and 220 South Meadow. How's that?
Probably want to angle that mic up at you a little.
How's that?
Good, thank you.
We're proposing building two new hangars, 4 units, 2 buildings, 218 and 220 South Meadow. We're basically expanding the units that we built at 216 South Meadow about 9 years ago. They're your basic box hangars. I brought some renderings and the landscape plan, as you had asked for that. Can I, yeah, there we go. Yeah, I got it, it's working. This is the view, heading east on South Meadow. This is actually the first thing you'll see when you hit the airport. And this building here is the existing building at 216. This is the proposed building at 218, and this is the proposed building, and it covers the back. You'll see it keeps on going. This is an aerial view. So these are the existing 216 hangars. This is 218, and this will be 220. Identical landscaping, construction, colors, maybe a little more modern efficiency. This is the view heading, this one's heading east, the other one's heading west. This is heading east. As you leave the airport, again, these are the existing hangars, and this is the new proposed 220. This is the back. You access it off of an access road, which is right before the airport property. And as you drive in, this would be 218, and this would be 220. And over here is the boatyard. This is looking down the ramp. Again, these are existing hangars. This is the new 218. These are the 3 units at 220. Give you a little more perspective. Looking from South Meadow. Now you're heading east on South Meadow. To the right is 218. Sorry, to the left. To the right is 218, forward is 220. This is the back from the access road. That's the middle unit of 220. Again, you're sort of leaving the back driveway that's not visible from the road. That is a Cirrus SR22. And again, the view from the ramp, looking out towards South Meadow. And this is from the back, looking, that would be South Meadow. And I think I brought a landscape plan, but you basically get the idea, a lot of arborvitaes, a lot of hydrangeas. Can we do this one? So this is, you got it. That's the landscaping plan, your traditional 2D boring view, but you get the idea, the darker buildings. This is 216, the existing building, these are existing landscaping. This will be upgraded. Here's 218, here's 220. This is the back side of it you won't see from the road. Here's the access road. Again, this is the most northeastern corner of the airport. It's what you're going to see when you get to the property, the first thing you're going to see. The other comments I'd make on the new buildings is they're going to be carbon-free. They'll all be heated with heat pumps, air to water, radiant heating. 218 will be over-insulated. We're hoping, at least for 218, to be net zero. All of them we built solar ready. Once we recover financially, we hope to add solar panels and mitigate some of the electric costs. But there's no gas, no carbon going into these buildings. Any questions?
Thank you very much. Let me bring it to staff first.
So not much more to add. I think the only thing I would say is that these hangars are typical for the airport, and these will be newer looking ones than some of the other ones, but it's a typical hangar design that you see at this airport or any airport. The airport commission, and one of the commissioners is here tonight, they have approved this also because it's on the airport property too. And the only issue we had was that they needed to show us some landscaping. Landscaping's pretty limited overall on the site, but this is clearly, will hopefully set a standard for future development there with additional landscaping. So again, it complies, and we're recommending you notify the building commissioner that the site plan complies with the zoning bylaw.
Were there, as I was looking through, I noted that there were still some outstanding comments from engineering. Do we know if those have been addressed or if those are the types that need to be addressed before our approval?
I just received those yesterday, some minor drainage things, and I'm going to go back to Outback Engineering and address those, but, and then ongoing requirements that would be standard. So nothing significant, but I'm going to address those immediately.
And they'll have to be addressed before they get a building permit.
Thank you. I will bring it to the board. Any questions? Let me start with Ms. Keene.
Thank you, Mr. Chairman. Is there any signage that is included in this plan?
No, these are all private hangars. The existing hangars don't even have the street numbers on them, no.
So no signage is needed? Okay. And I saw that you are on town water and private septic. And I just know that the airport itself, and maybe the commissioner can explain, has come to town meeting at least twice in the last few years for increased funding for the sewer system, the septic tanks there. And I'm wondering how this impacts that, because you're going to add a bathroom. This is an additional bathroom. So I would like to just have a comment on that.
For the record, my name is Douglas Gashati. I'm the Vice Chairman of the Airport Commission. I'd be happy to answer that question for you. We are under capacity at the moment. The funding we are looking for is to modernize and update our current sewage treatment plant. His 1 bathroom or 2 bathrooms per hangar will not affect our overall flowage or capacity for the airport whatsoever. And while I am here, I'd like to affirm the airport's total commitment and recommendation for his project. Everything that he's done in the past, he's exceeded, and more than we've asked for. He's very much an asset. It's one of the nicest things you see when you first come to the airport. He has impressed us every time he's come before us to do something. So as far as on behalf of the Airport Commission, we would like to formally endorse our approval.
Well, thank you for answering my question about the septic and for your endorsement. Thank you.
Thank you. Mr. Bennett, questions?
No, I'm the understanding this is you're going to be tying into the airport sewer plant, not private septic. Is that correct?
That is correct. It's the airport, his own private sewage treatment plant.
Okay, so the leaching pits are drainage leaching pits that I see between the buildings here in the site plan.
There wouldn't be any leaching pits per se as far as septic goes, because it's in a forced main system from that side of the airport to the sewage treatment plant. It's a forced main, so there wouldn't be any leaching for the septic.
Okay, yep.
If I could add real quick, they're basically unoccupied. There's not like there's somebody there 40 hours a week. So there's very, very low utilization of the bathrooms and sinks and a whole bit. There's just storage for aircraft, so it's not normally occupied.
Understood. Yeah, I think that as long as the engineering comments are addressed, I think it's a good project.
Mr. Donaldson, questions? Okay. I have no further questions as well. I am willing to, even though this is just site plan review, I'm certainly willing to entertain public comment on this if there's anybody in the room who wishes to speak regarding this project. Seeing none, Mr. Hartman, anyone on Zoom?
Anyone on Zoom interested in speaking? I'm not seeing anyone.
Okay, seeing no public comment, I will bring it back to the board and entertain a motion.
I'll make the motion to approve.
We have a motion to approve, and I'll phrase it as to approve site plan review for 218 and 220 South Meadow Road. Do we have a second?
Second.
Mr. Donaldson seconds. Any further discussion? Seeing none, I will call for a vote. All in favor, raise your hand. It is unanimous. Thank you. Moving on to our next item of business, we have a presentation which is identified as confirmation of Red Brook's affordable housing commitment, comprised of 113 income-restricted units in addition to 1,175 market rate units.
So if I could just start, and then we'll have Dan Gorsica from Red Brook speak after that. But just a few points to make. So as I've said before, a couple different statements. We know that creating affordable housing for the residents of the town of Plymouth is a priority that's been set by this board, by the select board. And I've said in the past, and I think it's important to just keep in mind that creating affordable housing is the responsibility of the entire community, and that it's not simply something that we can look at developers and say, you need to solve this or create this problem, or solve this problem or create solutions. That it's really a community situation. When we look at affordable housing in the community, it's always interesting that I know the board always looks to try to minimize the impacts of development, minimize development and what occurs, but affordable housing always comes at a cost of higher density of development. Carver Road, if we look at that project, that's over four times the density of what normally would be allowed. Thorndike on Little Sandy Pond Road is double the density of what normally would be allowed. And on State Road, we have 24 apartments right across from the start of Siam, where none of that would have been allowed except because it's affordable. So again, it's always difficult for my office and this board to have that trade-off between density to create affordable housing and trying to minimize impacts on the community. I just also would point out that our inclusionary bylaw states that once the total number of dwelling units is established within a project based on the underlying zoning by right dwelling units, there shall be added to this unit count affordable units. The Red Brook special permit and most of the associated documents that we see refer to the 1,175 number. That's the number we see throughout the documents, and there's really no reference to how we deal with affordables. But again, I look at that special permit, and if you look at that special permit and referring to that 1,175 units, it says it's the base density, again, which is very consistent with the affordable language of the inclusionary bylaw. It's base density and transfer of development rights. So again, unfortunately, I wish that this was clearly noted, but it's not. As we look at what was required by the bylaw, and this bylaw is a little different than others, but the requirement for this project was 74 affordable units. In every other development this board deals with, those units would always be in addition to what a base density is. So again, when we look at how we deal with every other project, you have a base density, and those 74 would be above and beyond what the base density is. I would also note that as part of the special permit, the 80 Makepeace group agreed to add 29 additional affordable units above and beyond that 74, and then through the town meeting process, they added another 10, for a total of 39 additional affordable units above and beyond what they would have been required to do just on their own. So for me, it's very hard to look at that and argue how Makepeace should be penalized when they've actually added more units than what they were required to do, and somehow penalize them to say, now we're going to take away market rates because you've done more. And again, it's difficult for me to look at this and say, we're going to treat this project differently than any other project and require these affordables to be part of your base density. So again, I wish this was better worded, and I wish it was clearer what we had when this was written, and as we've gone through this process. It's something we probably should have looked at 2, 3, 4, 5 years ago. But as I look at this and how we treat other projects, it's not clear, but I look at the way the bylaw is written, and that affordable should be above and beyond what your base density is. Thank you.
Thank you, Mr. Hartman.
Thank you, Mr. Hartman. Although I do not have a presentation, but I just have some words that I would like to read. Good evening, Mr. Chairman. For the record, members of the board and staff, my name is Dan Gorsica, Vice President of ADM Agawam Development and Project Executive for the Red Brook community. As noted in our memo to Director Hartman and Chairman Bolton, we are here this evening respectively to request that the Planning Board clarify and confirm that a customary practice of counting inclusionary housing applies to Red Brook in the same manner as the other Plymouth project approvals as represented in the inclusionary bylaw. To provide some history, in special permit dated May 13, 2008, regarding the Red Brook development project on Wareham Road in Plymouth, the Planning Board approved Red Brook with a housing component under 3 sections of zoning bylaws: transfer of development rights, traditional rural village development, and inclusionary housing. The housing component has always been based on the right base density and anticipated transfer of development rights from a variety of areas within their own by right base density. As required by the special permit and the inclusionary housing zoning bylaw, Red Brook's housing component must allow the creation of affordable units equal to 10% of the transfer of development rights usage. Although the estimated transfer of development right was 736 at the time of the Planning Board's approval of Red Brook, which would have resulted in the 74 required income-restricted units. We have agreed to exceed that base requirement to provide 103 affordable units. This commitment subsequently was memorialized in the Memorandum of Understanding with the Plymouth Office of Community and Development, most recently dated in May of 2019. We are continuing the advancement of affordability at Red Brook that exceeds the base requirement as referenced in the MOU. In fact, as part of expanding the affordable housing offerings at Red Brook, as you folks know, we have engaged the Grantham Group, a Massachusetts-based developer, to develop senior housing, 62 deeply affordable units. Most of them are at or below 60% AMI. Ultimately, the MOU is not a project approval, but rather an outgrowth of the proponent seeking to provide more affordable units than is required by applicable zoning. Upon increasing the total income-restricted unit count to 113, under the controlling decision, we anticipate updating the MOU to reflect the increased affordability commitment. By way of comparison, the latest estimated transfer development right usage of Red Brook and its completion is 546, resulting in a total of 54 required income-restricted units, well below the 113 now proposed. Consistent with Plymouth's practices of requiring inclusionary housing as additional unit count above proposed market rates, adding such 113 affordable units and the 1,175 market rate units approved for Red Brook would result in a total of 1,288 mixed income units. We respectfully request the Planning Board to clarify and confirm their customary practice of applying the inclusionary bylaw, applying it to Red Brook in the same manner as other Plymouth project approvals and as stated in the inclusionary bylaw. We understand there may be questions about impacts to the area, and we want to note a few following items. The traffic engineers confirmed that the projected total number of vehicle trips resulting from 1,288 mixed income dwelling units is within the permitted limits of the special permit. The engineer of record of operator of water and wastewater system confirmed that the on-site water and wastewater systems have capacity for those 1,288 mixed income units. The environmental engineer of record confirms that the project continues to advance placement and land conservation restriction. To date, 1,761 acres have been placed into permanent restriction. Currently, we are advancing an additional 374 acres along the Agawam River corridor. And it's important to note all other Red Brook development programs such as commercial space, community recreational facility, the on-site water and wastewater remain the same. As recent as yesterday, we held 2 informal gatherings where we invited the entire Red Brook community to come to the new Cranberry Coffee Corner location to ask questions about permitting, development, and affordable housing. My team and I answered questions for about 4 hours over the course of 2 gatherings, one in the morning and one in the evening. Some of those folks, a lot of those folks, are attending here this evening. And I think they will agree that even if they didn't like some of the answers, that it was helpful, and it was a helpful open dialogue, which we will plan to do again. Regarding Red Brook's affordable housing, the concern we heard was the management of Red Brook would be turned over to the Landowners Association before the matter was fully resolved. It's a timing thing. I assured our residents that you would not allow this to happen, neither would we. We also assured our residents that finished landscaping or future top coat in neighborhoods will not be delayed because of these matters. We spent the last 12 to 16 months working with the Grantham Group and the town to bring 62-unit, deeply affordable senior housing project, most units below 60% AMI. As you know, during that process, we've addressed ultimately all the planning issues and all the comments to the point where numerous town officials, town meeting members, and residents of Red Brook were prompted to speak in favor of the proposal that they initially opposed. In closing, let me just say that housing affordability is a complicated topic, as you all well know. One thing that public policy makers seem to agree on is that the way to make housing more affordable is to create a greater inventory. That's the premise of inclusionary zoning. Allow developers to build more housing. The cost to construct affordable units is helped offset by those market rate units. I'm just asking for clarity and confirmation that the same reasoning applies to Red Brook. Thank you.
Thank you, Mr. Gorsica. Unless the board feels otherwise, I'm going to open this up to public comment first before. A few ground rules on public comment, because I know we have a lot of people here who want to speak, and I want to hear from people. But per our practices, we're going to limit this to 3 minutes per person to speak, and I'm going to remind people that the topic is affordable housing. That's what's on our agenda. We don't go outside of our agenda because open meeting laws say we don't go outside of our agenda. So while I appreciate people have many things that they may wish to speak about, what's on our agenda tonight is addressing the issue of affordable housing at Red Brook, what their commitment is and what their obligations are. So with that, we will hear from people who want to be heard. Just please, fine. You first, and then next, please. So please, I ask you to step up to the microphone and identify yourself for the record.
Yes, good evening. Kimberly Karras from 9 Sunflower Way. I just want to comment on a few things, and just the number first. So this is basically whether the 1175 governs or the new number, the additional. So I'm asking the planning board tonight to preserve and uphold the integrity of government. ADM should be held to its obligation under the 2008 permit and the most recent MOU. In the special the special permit, ADM agreed to provide 103, now it's 113, units of affordable housing. From 2008, this amount was inclusive of the 1,175 units authorized. Now, all of a sudden, in 2024, ADM wants again to exceed the number to 1,275 units. If you look back to the planning board minutes from March 10th of 2008, it is recorded that Michael Hogan from ADM said, quote, the total unit count would be 1,175 units, of which 103 units would be affordable housing units. All of these documents, this is very critical in a legal sense, all these documents, the special permit and the 2 MOUs are recorded instruments. Why does that matter? Well, under case law, and specifically, I will turn to Supreme Judicial Court's decision of Devine versus Town of Nantucket, 449 Mass, 499. The court emphasized that the recording of instruments, legal instruments, serves a vital purpose to notify purchasers, such as the residents of Red Brook, of existing claims. The recording creates a public record from which prospective purchasers of interest in real property may ascertain the existence of prior claims and interests that might affect them. This does affect the residents of Red Brook, insofar it stresses the infrastructure. But so I ask that the bylaw at hand be interpreted in according with the case law, the relevant case law. The provision in the bylaw, 207, section 7.5, that Mr. Hartman spoke of, it does not authorize additional units beyond the 1175. I argue that that interpretation is incorrect. The recorded instruments have to be construed in the purpose, with connection with the purpose of the bylaw. That's another case law. The purpose of the bylaw is stated in 207.7a. The purpose is to promote development and availability of housing, affordable housing, not private developers' rights to build additional market rate units. I don't see that anywhere in the inclusionary housing bylaw. The protection, again, is affordable housing, not creating market rate units for developers. The language here, there shall be added to and included within rental projects, so that once the total number of dwelling units is established, this is in 207.7, there shall be added to and included within. Added to and included within, well, that's totally inconsistent. That's sloppy drafting. So when you have an incongruity like that in a bylaw, you have to look at it in accordance with the case law, with what a court would do if we asked for a declaratory judgment on what this means.
Ms. Harris, you're at 3 minutes and 45 seconds, so if you could wrap it up, please.
Certainly, sorry. Well, I just would ask you to read it basically as if it's inconsistent, it has to be read in accordance with the purpose of the actual Inclusionary Act, which is to protect affordable housing. However you construe the language, this affordable housing number is not going to change. ADM has to provide the 113 regardless. We're just talking about additional density market rate units. And last, I'm going to just say the agreement says the special permitting granting authority and the applicant can mutually agree on a number that exceeds the basic number, which is the 10%. And here, that's exactly what happened. There was a mutual agreement apart from anything else in that paragraph, and that was a special permit and the 2 MOUs, which were recorded instruments.
Okay.
Thank you.
Thank you very much. Good evening.
Good evening. I'm Scott McMillan. I live at 51 Wisteria Road in Red Brook. I would respectfully urge the board tonight for two things, please. One would be not to approve the request being made by ADM to increase the total number of housing units at Red Brook from 1175 to 1288. The second would be to request or compel ADM to complete the new home construction on the 8 vacant lots in use areas 10, 11, and 12 before consideration is given to any other ADM approvals or requests. I'll just go into a little bit of detail. I won't speak anymore. The previous speaker spoke it much more eloquently than what I can do. That the pertinent documents, the 2008 special permit and the MOUs, I believe, are very clear that the total number is 1175. Red Brook homeowners have bought into the community based on representations by ADM that the maximum number of units will be 1175. This number is important to residents given that self-governance will be achieved upon reaching 95% of build-out, which we want to happen quickly. Additional preservation of open space is an important consideration by Red Brook homeowners and ADM promotional literature alike, which is maximized by not increasing the total number of units. ADM, it was described before that regardless of whether the number is increased, that they still have the requirement to build this certain number of affordables. To date, more than 1,000 units have been occupied and only 15 affordables have been built. They backloaded the entire process. They lost the opportunity at the outset when they were building and selling less expensive multifamily units such as townhomes, rental apartments, and twin homes that would much more affordably be handled as affordable units. Now all they have left is larger single-family homes where they can't possibly make those affordable, including the units in area use 10, 11, and 12. Regarding those units, ADM has not fulfilled the prior commitments to provide a single affordable home in either area use area 10, 11, or 12. I live in use area 10, which is Deer Pond Ridge. I do have a certain vested interest in requiring ADM to complete the existing subdivision before the board provides any additional approvals or requests. These relate to issues of resident safety, neighborhood appearance, which includes unfinished home construction and the numerous vacant lots, and the fact that the final road paving can't occur until the subdivision is completed. So, in summary, it's disappointing to me that the board has not adequately held ADM accountable for the requirements of the special permit and the MOUs. especially with respect to construction of affordables in noncompliance on other requirements at Red Brook. Accordingly, I respectfully urge the board to consider my comments and not to approve ADM's request to increase the total number of homes at Red Brook to 1288. Thank you.
Thank you, sir. Good evening.
Good evening, Mr. Chairman. Through you to the board. My name is Michael Cornelia Power, and I live at 21 Wisteria Road, which is, I think Mr. McMillan said, use area 10, but it's Verbania and Wisteria, and that neighborhood is called Deer Pond Ridge. And I just have one or two questions, please. In our neighborhood, Deer Pond Ridge, there are 3 single-family lots that have been deemed Chapter 40B affordable. One of them happens to be next to my house. And my question is with these Chapter 40B designated lots, do you know, does that designation, is it a deed restricted designation that runs with the land in perpetuity, or does it, in other words, does it survive the first owner? So say somebody buys it under affordable Chapter 40B, is it always designated Chapter 40B affordable, or is that only with the first owner?
These are not necessary. These don't fall under Chapter 40B. These would be deed restricted affordable homes, which means that it is a deed running with the land. It runs in perpetuity. That's what the obligation is under the permit, just so we're clear. The obligation under the permit is for ADM to arrange for the construction of 113 units of various types, whether that be ownership or rental, that are deed restricted in perpetuity.
Thank you. So if I understand that correctly, I just want to recap in layman's terms, it'll always be an affordable housing lot. And it has to be conforming to the other homes that have been built there because they're single-family homes.
That's correct.
What if it's a different builder?
Well, I think, again, it's always difficult to get into hypotheticals, but it has to be consistent with the neighborhood. In other words, someone can't turn around and say, because their permit is for those single-family homes with a certain design elements. That's what was presented to the board when we open up any of these use areas. So it would have to be consistent with that. Anything that would be inconsistent with that would actually be in violation of this board's approval of the use area.
Okay. And then does the planning board know why the three lots were undeveloped? They remain undeveloped. Do we know why an affordable home wasn't produced, developed?
We will ask that of the developer when they get an opportunity to respond to any further questions. So we will present that to the developer.
Fair enough. Thank you.
Thank you.
Good evening, Keith Grablin, 4 River Bridge Way. Thank you to the board for letting me speak tonight. I'm going to start a little different tack. I'm going to read from a website called Developer Transition and Developer Issues. Paraphrasing from the Alec and Marcus website, current ADM and LOA lawyer that represents us currently, the landing page for that heading, Developer Transition and Developer Issues, states the transition of an LOA from developer to landowner control is traditionally the most difficult time for a development. The transition can be contentious, and it's often difficult to get the records and access to financial information necessary to operate the development. Your LOA needs legal guidance at this critical juncture. Without it, your LOA can be left with construction defects, budget shortfalls, and insurance nightmares. The ugly truth about LOAs is that some developers will take shortcuts whenever the situation presents itself. Others will take shortcuts if economics dictate. Developers are sophisticated. Landowners are not. Developers often believe they have a license to do whatever they want because it is their development and they will attempt to use their sophistication to their advantage. Why do I mention this in my opening? Because during the build-out, our only leverage as landowners during this build-out is the state and town agencies that regulate such developers. DEP Water and Wastewater, DPU for Agawam Springs, from the state have been very cooperative in listening to the landowners' concerns. Their regulatory oversight, while not perfect, has been at least transparent. From the town side, we have Planning Board, Planning Department, Inspectional Services, Health Department, and others that bring their oversight and concerns to how this development is built out. When state agencies and town boards and departments don't hold these developers to the conditions of their permits, it leads to our meeting tonight. Affordable housing could have been solved if town boards and departments had held ADM to honor the commitments as Red Brook was built out. This was not done. Use areas were approved, certificates of occupancy were issued without these affordable issues being addressed. Now in the 11th hour of our build-out, we now hold ADM accountable for not adhering to the special permit they were issued. 2021 was the year that should have made this meeting a moot point in our town if they had held ADM account for affordable housing. Because there's no transparency and communication between developer and landowners, this lack of sharing of vision has led us to this unfortunate situation. Currently today, we only have 15 deeded restricted apartments, and we have over 1,000 occupied units. Why 2021? Coming out of COVID, demand for housing in a community like Red Brook exploded for our type of housing. I went back and looked today, over 6 planning sessions with the planning board in 2021, 330 additional units were approved, 3 times the yearly average of 100 that we're averaging between 2015 and 2020. End of 2021, over 950 were approved and 641 were occupied. Let's just take 10% of the 641.
Mr. Gravelin, it's
Yes.
3 minutes and 50 seconds, so
Okay,
I'm going to
let me
ask you
just
to finish up quickly.
So basically, we only have 15, we should have been around 64. Why the history lesson? Because of lack of enforcement, this has led to unintended consequences of cost overruns on wastewater and landscaping in the millions of dollars. So as Mr. McMillan said, if we had done planning at an earlier stage and leveraged some of the homes that were already built that had price points lower than they are today, we would be a lot further along when it comes to affordability in housing at Red Brook. And I'll just finish with that. So basically my ask from ADM tonight is come clean on wastewater and have a resident meeting, the good, the bad, and the ugly. Consider transition at 95% of the 1175, not 1288. You will have all your use area approvals before hitting that number, no risk to the finished build out. Be more transparent with community on financials. My ask of the planning board and town departments, hold ADM accountable and enforce the provisions of the permit, no COs unless compliant, and make sure the current so-called affordable are built or brought back to market to finish those neighborhoods Mr. McMillan had talked about. Those residents deserve better than being strung along without finished neighborhoods. Finally, do your job of protecting residents from this happening again. We, the Red Brook landowners, have suffered the consequences of a broken planning process in Plymouth. It might be too late for us to get satisfaction, but thank you for listening to my concerns.
Thank you, Mr. Gravelin. Anyone else in the room?
Hi, Joe Hutchinson, 14 Summer Sweet Circle in Red Brook. I applaud the speakers before me and underscore many of their points. They covered things that I was going to cover, but basically, what I would like you to do, just as others have said, is limit this account to 1175 rather than raising it. And I'd also, though, since we're here at the planning board, urge ADM to plan and to be transparent about the plans. I think that if they were inclined to be just a little more transparent about the plans, that the residents would have time to digest details and understand what might be good or not good about the proposals, and have conversations to adjust the proposals so that we can avoid the boards not getting into arguments about this. Basically, if they did that, then all the boards, the planning board, ZBA, building inspector, would be able to do their jobs of protecting residents of the town, which is essentially what you folks are up there doing. So I urge you to hold to that number of 1175. Thanks.
Thank you, Mr. Hutchinson. Anyone else in the room?
But I'm last.
Not quite.
I think most of my comments have been covered.
Could you just identify yourself for the record?
Jeff Howe, Sunflower Way, Red Brook. And I do love living there. Most of my comments, I think, have been covered so far, but I do have a couple of things. There are some unfinished lots in Red Brook that are a real eyesore. Two of them on one street, the foundations have been sitting there for quite a while. At one point, they took and built 2x4 border around it. I guess that wasn't safe enough, so they put chain link fence around it. And now they've hydro-seeded the lawn up front of a chain link fence foundation. So I guess my question is, what are they going to do with that? I mean, that can't just sit there like that. If they're going to do market price homes, then they should do that. I can't see how those would be affordable anyway, but they got to do something with those too. And I know there's other vacant lots around. People want some answers as to what's going to happen with those. My second comment is when this community gets turned over to the residents at 95% build out, if the affordables are not built at that time, are the residents going to be held responsible for that? Or is that going to be just waived or something? In other words, they got to get caught up. ADM has to get caught up with their commitment, which they made back in 2008. They got to get caught up so we don't left holding the bag when we take over the finish of Red Brook. So I don't want them to build any more than 1175. I think there's plenty of homes in there, and congestion is going to be a real problem if they go to 1288 and the 62 units get built of affordable housing that they're already planning. It's going to be a lot of traffic problems. So I guess there are more questions than answers, but that's my two questions.
Thank you very much. We'll present those to the developer, and the developer will have a chance to answer those for you.
All right, thanks.
Good evening.
Darcy Moss, 32 Wisteria. First of all, thank you, Steve, for taking the time to come to our neighborhood. We greatly appreciated that. Math question for me. We keep talking about a vague number of current doors. How many doors without the affordable?
Oh,
That should be an easy question to answer.
You ask the questions of the board then gives, we don't do back and forth here, just to make it easier, because then someone has to keep coming back up to the
So
microphone.
we should know, all of us should specifically know how many doors, if they want to take the affordables out, how many doors are there right now? How many doors are coming in Area 13? How many doors are coming, all market value, except for whatever ones they have scheduled for affordable, are coming in Area 14, okay? Added up, without the affordables, we're getting pretty close to the 1175. In those, with one other area, I think, that is still in there to be developed, there's land. So we're getting close to that number, you know, once we get the final numbers on that. And we still haven't addressed the fact that even if you pull the affordables out separately, they only have 15 out of 113. Regardless of why we got to the 113, they only have 15 out of 113. 98 more units have to come somewhere. So, you know, there's a lot of different arguments and everything, and then there's some basic math here. You can't get 98 affordable single-family homes in these remaining neighborhoods. It's not feasible to do the 8 that are sitting out there right now. You can't get them done. So there's got to be some other plan to get 98 affordable houses in there prior to them hitting 95% of development, or it's a large problem for the current residents. So to me, I understand the argument about the 1175. I was always told when the house was marketed to me and everything else, I was always told, they called it full disclosure. My house was next to an affordable house. We questioned it. 1175 was the total number, including affordable housing. Okay, but even if you find a way to concede to, you know, the argument that those should be separate, what I'm saying is you still have a serious problem. There's still going to be somewhere along the line here of the development, you know, waivers for, you know, more houses. So that's all I have. Thank you, Board.
Thank you very much.
Good evening. Ed Russell from Long Pond Road. To the extent that these affordable houses are additive to the 1175, I'm opposed. And I'm opposed for traffic reasons. People on Long Pond Road, Halfway Pond Road, and Bourne Road have seen a tremendous increase in traffic, and it's only going to get worse. Fortunately, there will be a light at Halfway Pond Road and Long Pond Road. That will help a lot, because when I go by there at 9 o'clock, headed in the other direction, thankfully, there are 15 cars backed up, excuse me. And the light will work for a few years, and then it won't work anymore. And we're going to have expenses. The town is going to look at road improvements, infrastructure improvements to carry all this development that's coming forward. So this may not seem like a lot, but now I'm against any. Thank you.
Thank you very much.
Yeah, thank you, Mr. Chairman, for being allowed to speak tonight. My name is Paul Jean. I'm a resident at 33 Wisteria Road in Red Brook. And when you started this portion of the hearing, you referenced the commitment of the town to affordable housing, and this is a priority. And what I would say is, we're not seeing that priority executed by AD Makepeace. So there are multiple lots designated as affordable that have not been built. Now, Mr. Gorsuch he spoke to a series of open public forums that he had yesterday with members of the ADM team, with residents of Red Brook. When we posed the question of how these affordable units were going to be built and when they were going to be built, literally, Mr. Gorsuch shrugged his shoulder. He said he didn't know how they were going to be built, and in fact said, given the changes in construction costs, He seriously doubted whether affordable units would ever be built on those 3 lots. So my question is, are we going to hold the developer accountable for their commitments? I think that's the fundamental question that speaks to affordable housing. If the units are not being built that were supposed to be built, then what are the guarantees going forward that additional units are going to be built? We just want that answer. So, because I think the residents in these communities would like to see these affordable units built, but they're not being constructed. There's no timeline, and there's no answer for how that's going to happen. So, thank you very much.
Thank you, sir. Anyone else in the room? Yes, you do. It's because that's where the recording goes.
Paul Baker, 6 Vermina Drive. I guess my question to the board is, what guarantees do we have that if we allow additional growth within Red Brook, okay, is the additional neighborhoods going to end up like the areas that were currently developed in that capacity with affordable housing lots? Okay, what guarantee do we have if we allow 54 additional houses to be built, okay, and 10% of them have to be affordable housing, okay, what guarantee do we have from the planning board or from AD Makepeace that they're not going to have 5 additional lots that end up like Deer Pond and Area 10, 11, and 12? I guess my question is, going forward, what I would like to see is I would like to see a 9 and 1, okay? So release 10 additional houses, okay, with the first one being built for affordable housing, and then 9 additional lots being released, okay? So what that would do, it would hold the developer to the affordable housing, okay, and upon the release of those 10 lots, when those are completed, an additional house would be built for affordable housing, and then 9 additional. So what we would do is, once you release 10%, that one affordable housing would be built, okay, guaranteed, okay, before any release of any other building permits are released. But what guarantee do we have from the planning board that that other neighborhood isn't going to end up like the 3 existing neighborhoods with foundations, with chain link fences, and basically on Deer Pond Ridge, you know, we got 3 additional house lots there that we were told from a representative, and I'm not going to mention the company, that, oh, it was going to be built in April. Oh, we got a house going in April. Well, April's come and gone. Oh, well, it was going to be started in September. September's come and gone, okay? And the developers pulled out. We've had 2 developers pulled out, so there's no accountability to them. But what accountability do we have to AD Makepeace to make sure that those affordable housing lots are going to be built on? And that's all I have to say.
Thank you very much.
Hi, Maury Ryan, 33 Mountain Laurel Way in the Red Brook community. The MOU from the 2019 MOU for ADM states that they will construct affordable units at a minimum proportionate rate of 10% of the market rate units constructed within each 12-month construction cycle. Your committee and the town policies call for the building inspector to not issue any building permits until he or she has obtained confirmation from the planning department that the developer is in compliance with its obligation to construct affordable units hereunder. And page 4 of 6 of that, and section 13, says the parties agree that as a condition precedent to the issuing of any occupancy permits for the project, the developer shall be required to demonstrate compliance with all terms and conditions of this agreement. And yet, if you look at your own records, you will see that occupancy permits are issued on a regular basis, and we have new neighbors moving in every week. When will they be held accountable? And will you follow the rules that you've established to make affordable housing real in this community? Thank you.
Thank you very much. Anyone else in the room? Seeing no one, Mr. Hartman to Zoom.
Is anyone on Zoom looking to be recognized to speak? You can just unmute yourself and go if you'd like. I'm not seeing anyone.
Okay, final call for anyone to speak. Okay. Thank the community very much for its thoughts, very thoughtful, thorough, and well-spoken comments, and I appreciate that. Mr. Gorsuch, if you want to step up, because we have some questions from the residents for you, plus, I'm sure, some questions from the board.
I tried to take some notes as far as the questions, so I will apologize if something's not answered. Mr. Chairman, if you guys could help me remember some of them. I wanted to first speak on the matter of the open affordable lots and the conversation yesterday. The residents are right. We don't necessarily have the exact answer on those. What I was trying to explain to the residents. Can you guys hear me okay? Sorry about that. I'll try to speak louder.
Can you hear him now?
Okay, I will.
You may want to
will do
step
my-
closer to one of the speakers. We are stuck with the acoustics and the systems in the room, unfortunately, and I do apologize for that.
I will do my. I didn't want to break the thing. So I'll do my best. The open lots, what I was referring to last night was, again, so these lots are deed restricted to the builders. They're obligated to build them. They're not being built. A lot of that primarily, I know, is because of the construction cost and the difference in the delta that those things make up. What I was saying last night, and I'm sorry if I wasn't clear, assuming these homes get built as affordable units, there is a concern because of general affordability in general, especially in a private community like this, is would those single-family homes actually be affordable for someone to buy and then maintain in a longer period of time? Those open lots we've cleaned up to the best we can at the moment. Again, I know and I understand that it's frustrating. We are just as equally frustrated on those. There's a few comments about the years and the times that have passed, and I know we've had a lot of conversations over the last 12 months, maybe even longer, about affordable housing, specifically with that Grantham project. I'm not suggesting that the company is not behind in affordable housing, but I just thought it was important to note again that the first several years of building at Red Brook, we were utilizing base density requirements, and those base densities, the way our permits were written, didn't require affordable. So first handful of years or so, we just weren't required to do them. The comment about transparency, you know, I struggle with hearing that comment. I think we do a very good job at trying to communicate. We hold meetings, whether Zoom or some in person. We send out email correspondence, communications. The comment about wastewater, we do plan on having a wastewater meeting. I know there was comments about the transition from an LOA perspective. You know, in my opinion, we've already started that transition. I made that comment last night. We have a resident advisory committee. They're heavily involved in our day-to-day business as it relates to, there's finance meetings that we have. They've been involved with scheduling, but not scheduling, budgeting rather. They know that they don't make the final say. They understand that, but they're involved in the processes. The last 2.5 years, when I took over the new position that I have, I made it a point to tell the advisory committee that, listen, this transition's going to happen. I said, and you guys need to know what you don't know. That's more important sometimes than knowing what you do know. And so we've made it a point for that process to try to gear them up for that transition. So again, on the transparency end of the world, I think we do a very good job. I can say for sure that I'm pretty sure we do We communicate more than, I would say, most private developers do, whether it's this town or this state. We don't want to leave and transition to the association in a bad place. We want it to be in a good place, and we want the folks here to understand what that involves. I did hear a comment about traffic. As the board sees, you have that traffic trip generation memo by Vanessa Hagan. They are traffic engineer of record, have been here since the beginning. As you can see, what their memo says is that for that full build out of 1288, it meets our permit. And that included all the off-site traffic infrastructure improvements that we have to do. Just bear with me, please. And the other comment I just want to make on the affordable, and we committed to 103, we're doing 113. We all have to just remember the initial thought process back, now I'm talking 2005, 6, 7, 8, leading up to the permit approval. A large component of that affordable was supposed to be a large assisted living facility. Now I know we're not doing assisted living, we're now proposing Grantham, a senior affordable housing. But you can't build one of those things with nothing around you. So you have to build a sense of community to supply one of those things. So that will be, somebody was asking about specific counts. That's a 62 unit building. Someone was also asking about specific unit counts. What we're talking about here tonight is 1,175 market rate units. And then it would be the 113 affordable units. To date, we have slightly less than 1,000 occupied units as it relates to the total market rates. The last thing I wanted to point out in the inclusionary bylaw, my opinion and my read of it, I think it's very clear that you add up the base density in all the areas, and in our case, you have the base density of where we are, plus all those base densities where our transfer development rights came, and then it specifically says you add up those base densities, and then you take 10% of that and you add to those units. And if I missed anything, I apologize, but I'm sure it will come up as the board talks.
Thank you, Mr. Gorska. I'm going to let the board ask its questions, and if there are if there are things that the residents had pointed out, I'm sure they'll bring that to their attention. I'm going to start with Mr. Donaldson. If you would prefer to defer?
No, I do not. I am ready. Okay. So one of the things I need to understand is the process on how Area 13 and the other areas were built prior. So I'm educating myself. I just want to understand. So basically, you look for builders to build in those areas, correct?
Yeah, so I just want to make sure I'm clear. Use Area 13 doesn't exist yet, so you're asking from like a previous neighborhood, like how do you go about doing something? Okay.
Correct.
So we'll use Use Area 10, for example. Use Area 10, that was the Valley Group. We had conversations with the builder. They built the entire neighborhood. So we're not selling one-off lots to just individual builders within the community itself. So that just works as a negotiation between us and the builder to purchase that neighborhood. We do all the design, permitting, and infrastructure. We come in here to get our approvals, and then we agree with the builder on all that stuff, and then we go forward with the process.
Okay, so once you make your agreement with the builder, they just build whatever you're asking them to build. So in that process, why aren't the affordable housing in those areas not being built during that process?
Yeah, at the end of the day, in that specific neighborhood, a lot of it has to do with cost. When we started that neighborhood, memory serves me right, we went through the process with one lot, got to the end, so candidly, between paperwork, scheduling, trying to find buyer, didn't work out. We actually then came and asked to take that lot, make it market rate, and we needed another one as affordable in that area. And
So whose cost? Is it your cost or the builder's cost?
So we deed the land over as affordable. The builder is in our agreements, the builder is the one who builds the house as affordable.
All right, so the builder is just the builder. they're not, only profit they're making is off what contract that you put together with them to build, correct? Or
I can't really necessarily speak to their profit, but they're building houses and selling it to a third party. I want to make sure I'm answering the question.
Right. So you as a developer
Correct.
are contracting a builder just to build, right?
Yes. Well, they purchase land and then build the home.
They purchase the land and then build the home.
Correct.
Okay. And you're not within where they've purchased, they have the understanding that there are affordable lots in those areas that are supposed to be built.
Yes.
So why aren't they not building them? And if it's in the contract that they've agreed to purchase to do X, Y, Z, and they're not doing it, then why isn't they not being held accountable? Because really, I'm not trying to get on you.
That's okay.
Right? I
understand.
Right. I'm not trying to get on you. But what I'm saying is, instead of everyone coming to you saying, hey, you're not doing X, Y, Z, it sounds like it's the builders who bought the land, had the understanding that they were supposed to build these affordable housing, and said, F Plymouth, and left.
I wouldn't phrase it in that way. I will say in the instance with the Valley Group, we did try. We tried to go the nonprofit route to see if that was something we could do to help lower the AMI, and candidly, nothing formulated.
So then what is the recourse for not doing something you're not promised?
That I would have to seek counsel with real estate counsel. That's what I would have to do. We have contracts, we have P&S agreements, we have closing documents, and that's something that I have to talk with counsel about. I'm just as frustrated. We are in a very difficult position, and I totally understand that, and I understand everyone's coming here tonight. I understand why. People are choosing to live in Red Brook. They are making a huge investment, and they aren't left with the best of condition right now.
And I'm going to give the community, the people that showed up here, much respect in the fact that usually people come here saying, you know what, we don't want affordable housing in where we are. There's other towns that they hear affordable housing, and they're coming with pitchforks and torches. And these people are coming out saying, hey, we want to have the affordable housing in here. We want to have inclusiveness in this community. And if we're not holding the people that's supposed to do it accountable, then we're failing everybody in the community. And I have a problem with that.
Please, no outbursts. I appreciate the enthusiasm, but we're going to go through this. Everybody can applaud at the very end if you like, but let's get this through. We do have things that we need to address. So I appreciate the enthusiasm, but please, no applause.
Now again, I don't want to be like I'm coming down on you, and I'm not. I wasn't here prior to 2008 and 2019 when the MOUs and all this other stuff was created, but I'm here now, and I want to understand it, and I want it to be corrected, or at least have a compromise between the development and the community. But a promise is a promise, and if a promise was made for something to be done and to happen, then we need to, between you and the town, I don't mean you personally, but right, that whether it's combining resources to make sure that we're holding the builders accountable, then that's something we need to do, because if it's happening here, who knows where else is happening? All right. So my next question is: so there'll be when Red Brook's at 95%, it's supposed to go over to the community. That's correct?
So there's a transition process through our covenants and restriction, yes.
Okay. And I thank you for saying that, you know, you want to make sure that the community is able to not be stuck with a burden with this. So with that being said, what is the plan prior to the 95% being completed? And that 95% being completed, that's the total development, correct?
Yep, 95% of the occupant. And when you say plan, you mean just an affordable in general, or plan like a more?
With the affordable.
Yeah, so a large part of it, or our plan right now, is grant them at 62 units. We have 15 units in the apartments right now, that's 77. One of our builder, well, two of our build, one of them is building them now. One builder now, Eric Pontiff, EJ Pontiff, who would be why we're, for our next neighborhood, he's building 3 affordable units right now.
Okay.
So those are under construction.
So that brings you at 110.
Nope, 62 plus the 15, 77, that's 80. And then we have 2 more in another use area, that's were recently approval from last year, that would be 82. And then the remaining, right now, we have proposed in use area, well, there's also the 5 vacant lots right now.
Okay.
The other remaining between use areas, 13, 14, and then a future 15, which we have not designed yet. That's where the remaining would go. I will tell you, my gut reaction from what we're experiencing with the affordable housing now, from a single-family perspective, it is my opinion as of now that I think the best way to go to deal with affordable housing is attached products and multifamily. And from a cost perspective and from an affordability perspective, that may be the better way to go. Now, I know if we ended up doing something like that and use those existing use areas, that would have to come through this board. But that's our plan. I know we provided the update, I forget, 6 weeks ago,
yes.
So that was part of that update. It's the same thing there. I'm confident with our current builder that's building the 3 affordable, who's doing the next neighborhood, that he would build those. And then the other use area that we are working on, it's a new builder. He's committed to build those lots. So it's really, what the struggle now is these 5 and to figure out the best way.
Okay. And so my next question is to Lee. When some of these proposals with the contracts come in regards to us dealing with the builders, do we have any capability or right to have our council look at those contracts to verify, to make sure that the language is in there that we can hold whoever's accountable for not doing what they're supposed to be doing per the contract?
Yeah, I think the best answer is that when we look at the next phase, the next neighborhood, that there are restrictions that this board puts on about when those units can actually be built or occupied as a condition of approval, and we do it up front when they come in with the next phase, so that, again, we've already talked to the chair about that too, that as we want to see what those commitments are, and that there'll be restrictions on what they can build moving forward until they have that affordable addressed, or at least done in a way acceptable to the board.
Thank you. And I'm just going to leave with a statement. I'm not a I don't favor affordable housing, affordable apartments, I'm sorry. I know it's a way to try to make the numbers meet, make the tax credits and this and that, but if I'm just a little, what's the word I want to use? I'm just a little when I see different developers come in and they want to build 100 apartments and only 4 of them or 3 of them are just affordable, I don't believe it really gives the right intent of making, and these are just apartments, not apartment. This is to me, apartments in that fashion is rental, not home ownership. And I'm more of a component of home ownership through affordable housing. And I believe that was the intent in the beginning when this was put together. So to try and just meet the quota with apartments, I am not a fan of that.
You're talking about condos, and you said attached
Candidly, I made a statement of attached product, whether it would be multifamily, well, whether it would be a rental or single or for a part.
If it's condos, I'm okay. I'm okay with that. But if you're just saying apartments,
Can I comment on
sure,
the
please.
condo aspect? And this comes back to the LOA. So, one, to clarify, in my interpretation of what's in the documents from an affordable perspective, it talks about rental or ownership. We're in an LOA. We have private utilities. It's not just the cost, the initial cost of building the house and then selling it. We do have to be mindful that there's an LOA fee, there's a water fee and a wastewater fee that is higher than it is, say, where I live in town. It's different. I have public water, but I have private sewer. I'm not paying an association fee. These people also pay real estate taxes on top of that. A condo would be a different situation where the fees would even be even more. So there's those two elements you have to balance. One, affording the purchase price, but then if all of a sudden you're paying an extra $500 or $600 a month, then you just have to think about that. I understand, Carl, ownership is a huge need. I get that. So we just have to take all those into consideration when we're talking about affordability.
All right. Thank you. I yield to you, Mr. Chair.
Thank you, Mr. Donaldson. Ms. Keene.
Thank you, Mr. Chairman. I'd like to address a little bit my knowledge of being on this board for 5 years. 2 years as an alternate and now 3 years as an elected member of the board. And we have subdivisions that have come before us, and each time these subdivisions come before us, we approve a certain amount of units, and then 10%, rounded up, have to be affordable. Some of the developers, not Thorndike, Megrico is an example, choose not to build the affordables on the site that they come to us with, but we ask them then to either put money in the bank for the affordables or to build it on another site. Sometimes we'll use Megrico again, puts money in the bank, but mostly he will build on another site the affordable units. It has never been my experience that those units are in addition to what we have approved on the planning board. That has never been my experience. So I can't agree in any way, shape, or form that 1288 is a number that I can vote for. I just want to say that up front because I have never experienced that additive effect. That's been my experience. Secondly, I wanted to say that we were told today that affordable housing is a community responsibility. It's not just the responsibility of the developer or the contractor. I can agree with that to a certain degree because we have the Community Preservation Committee. Now, I wanted to say, is the Grantham Group the first time, Mr. Gorsica, that you have used the Community Preservation Committee in order to put affordable housing into Red Brook?
Yes.
There was an opportunity then for 20-plus years before Red Brook was even a conception to use the community preservation, work with your developers. Megrico has been very successful in building affordable housing using the Community Preservation Committee to the tune of millions of dollars. That is a contribution from this entire community to affordable housing. And yet Red Brook did not choose to work with their developers in order to avail themselves of the community commitment to affordable housing. I think that's unfortunate. And so I agree that it's community responsibility, but then the subdivision or the community like Red Brook has to avail themselves of what the community can offer for affordable housing. That hasn't happened. That's a disappointment. At least you've moved forward now for the 62 units. And also, I don't want to, well, he's left, but I'm sure he'll be back.
He did need to just step out. He will return.
I don't want to repeat what my colleague has said. So I won't go into my multiple questions because, in essence, I think you understand what they would be. What I would like to do is apologize from me on this board. I can't apologize for my other board members. To all of you, residents of Red Brook, that we did not stop and say, before we approved new use areas, we did not stop and say, have you built your responsibility for affordables? We cannot move forward to approve another use area. We didn't do that. I apologize to all of you that are here today and to everyone in your community that we did not do that. I believe that's a failure of this board and that we should address that as a board, and we should do so publicly. So with that, I'm going to say, Maury Ryan, thank you for your clarity and everything that you have said since the issues actually with the Grantham Group came up. I really appreciate the way you address us, and I appreciate everyone that's come to the mic. But I just wanted to have a special appreciation for the way Maury presents to us. I agree with Ed Russell and the traffic. If you have ever tried to go to Red Brook or leave Red Brook during rush hour, you cannot get to where you're going on time because of the issues on Halfway Pond and Long Pond Road, which will only be worse. With that, I have one other question. I don't believe it's been answered. If you do not meet your commitment and the transition has taken place, who is responsible? I did not hear that answer. I thought it would be the first answer, Mr. Gorsica, that you would give to everyone that's in this room and everybody that's watching. But I didn't hear you answer that question. Where does the responsibility fall?
Well, if I read everything correctly, the responsibility is on us. I wouldn't see a scenario that we even get to 95% unless having this stuff resolved, the open lots and all those affordables, because I fully expect the next time we're in front of this board, the conditions will be different than they typically are. So I don't see us getting to 95% without having these things done, just because I wouldn't see the board necessarily approving further development until we have conditions in place that this doesn't happen again. But it's not the homeowner's responsibility to meet an obligation of our special permit.
Okay, so I'm just going to repeat that. It is not the responsibility of the homeowners to meet the commitment that Red Brook has to affordable housing.
Yeah, I wouldn't think so to build our houses, no.
Do you believe that you can, no, I'm going to phrase it another way because it's part of my apology from this board. Will you work more closely with the Community Preservation Committee and your developers to bring affordable housing more quickly as single-family homes to those vacant lots with chains around them? Maybe even putting an article in for this fall town meeting. I know it's getting late. it's getting very late for that because August, I believe, is the deadline. It might have to go to spring. But will you make a commitment to Red Brook to work with the Community Preservation Committee and your developers to get those lots built with affordables?
So I like that you asked, and I like that you brought that up. I'm a huge proponent of public and private entities working together, but I need to say that that process that we went through, we had a lot of resistance from our own community members, and some of them that are here tonight, about giving a developer money for affordable housing. I don't agree with that, obviously, and neither did a majority of town meeting members, but I'm willing to have those conversations with CPC. I think the CPC is a wonderful thing, and I think, again, any private and public partnership is wonderful. I will love to seek that. I am just letting this board know that I would expect further resistance from community members that are here this evening.
What I think you're talking about, the difference you're talking about is the Grantham Group is proposing apartments. What I'm talking about are the lots with chain link fences around it that are single-family homes. Resistance, we heard no resistance tonight whatsoever to single-family homes, particularly on those vacant lots. So I'm just going to say, again, from my perspective, that you will not feel the same resistance that you got from 62 units housed in one affordable apartment building, which doesn't appear inclusive because it's not throughout the community. So in that respect, I believe that I'm finished with my comments, and I appreciate everything that everyone has said here tonight. Thank you.
Thank you.
Thank you, Ms. Keene. Mr. Bennett.
Thank you, Mr. Chairman. So I don't have a lot that my colleagues haven't already said, and also the residents. But I do want to go back to what Ms. Ryan had said, that, and I want to get a clarification. Is it actually written in the MOU that for every 10 units constructed or given COs, 1 unit must be affordable? And that, because I'm fairly new on this board, it begs the question is how do we get here? How did we get here?
So the big problem with the MOU and the affordable is that, unlike other developments, the number of affordables is triggered by transferred development rights. So as you take development rights from Halfway Pond West, Halfway Pond East, Frogfoot, and you bring them into this property, that's when you trigger the affordables. So as Dan was saying, in early phases, there were no requirements for affordables because it was all the base density of the development. So,
prior to the TDRs coming in.
yeah, so it gets very complex because in the very beginning stages, and Dan can talk about it more, but the triggers didn't really work well that were in the MOU because you had to track the TDRs, and it was really more based on TDRs. I think, we've been talking to the Makepeace about their obligation, their requirements for well over 3 years now about how to meet this. And I think from a staff standpoint, if we ever got to the point where I felt like it wasn't cooperative, we'd be talking about ceasing to issue any more building permits or occupancy permits. That gets difficult too, because now you're talking about somebody who wants to buy a piece of property, they have it under agreement, and although we have great control by doing that, it comes at an impact to that future homeowner too. But again, so I think moving forward, talking about setting some real tough standards about what they get to do at the very beginning before the affordable's there makes a lot of sense. Looking backwards, it's very difficult. And I'd also point out a big part of this discussion is how do you do with a homeowners association when you look at the costs involved and then a homeowner's fee, and we've run into this in other developments, it's very hard to provide a single-family home in a neighborhood like this and be confident that the homeowners could actually maintain the property with all the other bills and costs there. So it is a very big challenge in neighborhoods like this to try to figure out how you make an affordable single-family house work. But again, I think the biggest issue was early on, it was based on the TDRs, so that MOU wasn't the best of fits there.
Thank you, Lee. That clarifies it somewhat, I think. It is very complicated, and I do feel that certainly going forward, because we're here now, and the past is the past. So going forward, I think we are going to need some sort of conditioning that will allow Makepeace to build the money into future sales prices or whatever, however that may work. And I know the market is the market and you don't control it. But it's my understanding that the construction of the affordable units is financed in part by a portion of the proceeds from all of the other units in the development. Is that a valid method, Dan?
If I was a home builder, that's how I would look at that, yeah.
Okay, I think that my colleagues have covered most of the other questions, so I'll let it rest there. Thank you.
Thank you, Mr. Bennett. I'm going to start by echoing what Ms. Keene said. Whether it was because of some poorly written documents, going back to the special permit, later on to the MOU, all the way to 2019, the fact that we have a very strange comparison between our affordable housing bylaw, referred to as our inclusionary housing bylaw, and the TRIVID development, and how those convert over. Whatever the reason, we let this get away from us. There's no excuse. There's maybe an explanation, but it's not an excuse. And this board takes responsibility for that. And I've said it before, and I'll say it again from myself and echoing what every board member has said, that stops. Stops now. So we have lots of things that we can talk about going back in the past. That's not going to help us. I wish it did. It doesn't. But we can address this going forward. We can do what we can to lock this down, to make it as clear as possible going forward, and to make sure, from my perspective, the priority is to make sure that obligations are met by the developer and the burden is not placed on the residents. And I know that that's something Mr. Gorska has echoed as well. That's how it's got to be. It is the developer's obligation to meet these requirements, and we need to minimize the burden on the residents, period. With respect, there's two issues before us tonight. Issue number one is how many units? And I've gone through this. I've read the permits. I've read our bylaws. I've read the circumstances. I appreciate the citations to the case law, but I can say that, for example, when we talk about our affordable housing bylaw, the words that have not been used today, everyone sort of read a part of the bylaw. No one read the whole statement. Here's the statement. Once the total number of dwelling units is established within a project based on the underlying zoning regulations and or applicable subdivision rules and regulations, the by right dwelling units, there shall be added to and included within the rental projects or ownership projects an additional number of affordable units consisting of not less than 10% of the by right dwelling units. That's what our statute says. That's our bylaw. That's what town meeting said we have to follow. That was passed in 2005, Fall Town Meeting 2005. That's what was in effect when Red Brook Special Permit was created in May of 2008. And again, no one on this board here was part of this process when that occurred. So no one went through and said, okay, how does this TRIVID thing affect our affordable housing? So instead, we have a permit. And the permit says that the River Run, the project, is designated as a traditional rural village community comprised of up to 1,178 new dwelling units based on the anticipated base density and transfer of development rights. 1175 is the base density number. That's what our permit says. And our statute says that that's the number which forms the base, and the affordables are on top of that. That's what our law says. May not be what we want. If we had thought about it, and we've done this a lot, we've looked back in the past and said, gee, wouldn't it be better if we had done other things? I've heard many times from this board, gee, wouldn't it have been smarter for us not to include apartments in the Pine Hills as commercial? We all want to look back and say, gee, we've learned from our mistakes. Maybe this was a mistake on our part, but that's what the statute says. Now, there's been a lot of talk about the MOU, and I think we have all misunderstood what an MOU is, because the MOU can't change the special permit. It's not a separate document that changes a special permit. The planning department, by signing an MOU with a developer, can't change the special permit. The only way that the special permit gets changed is by a public hearing before this board upon which we vote. And this would be a change, a significant change to the special permit. It would basically be saying we're going to take 10% of the units that could have been built per our inclusionary housing bylaw and reduce that. Now, just last year, Red Brook came before us and said, we'd like you to make a minor modification and allow us to add 10% of the units. And this board said no. 10% change in the units is not a minor modification. That's a major change. We have to have a public hearing and open up the permit. And they declined to go forward. The same thing happens in reverse. My position, I can't speak for my fellow board members, but my position is if someone came to me and said, I want you to mandatorily reduce by 10% the amount of units that somebody could build, my answer is there better be a darn good reason and there better be a public hearing about it, and we better have legal basis for doing it. So until we have that, that's not something I feel personally comfortable with. What I do feel comfortable with, though, is addressing how we get to the right numbers, how we get to what was going on. It was pointed out that per the MOU and per the permits, there can be an agreement to build more than the minimum required affordable housing units. And right now, if I were to follow the permit and our TRIVID bylaw and our inclusionary housing bylaw, even absent the MOU, even with the MOU, Red Brook's obligation is 54 units. Because the MOU doesn't change their obligation. What the MOU did in 2019 was say, listen, we don't know how many affordable units you'll be required to build, because we don't know how many TDRs you're going to be using and how many units you're totally going to build. Instead, there was an agreement. ADM came and said, look, no matter how many TDRs we use or how many units we elect to build, we're going to build 103 affordable units. And the town said, okay, if you do that, no matter how many TDRs you use or how many units you build, we will accept that as being compliant with our inclusionary bylaw. That's what the MOU says. And we need to memorialize that by a vote of this board. Not only that, not only the correct total number, but the additional 10 on top of that. So that there's a vote of this board that says we accept as a requirement of this 113 affordable units, because that's what has been presented to us as being the obligation that AD Makepeace is willing to assume. So how do we get to those 113 units? That's step two. That's the other part of what we're talking about, because we're at where we're at. So, Mr. Gorsica, and again, knowing you only have so much authority to speak on behalf of an entire corporation that needs to make all sorts of decisions, et cetera, and I am not going to make you give any commitments tonight, et cetera, I'm just going to give you some food for thought. Number one, according to the table you provided to us on the residential build-out summary, you are proposing 19 units of single-family affordable housing. I personally do not believe that is achievable. I think what we have seen, and you have very appropriately stated it, is that single-family affordable housing in a community such as Red Brook, with private utilities, with LOA fees, with all the things that go into living in a wonderful community such as Red Brook and all the expenses associated with it, single-family affordable housing is not practical. My concern is that what I have seen as I looked at those empty lots sitting there and the lot that was built as single-family affordable and could not get someone who qualified for it, is that single-family affordable is not a practical solution. I don't see you getting to 19 units. And my further concern above and beyond that, and I've spoken to others about this, is that even if you were to get someone qualified and in there, in one of these single-family homes, their ability to stay there remains in question. Because as these costs go up, as the costs of ownership go up, as the LOA fees go up, as insurance costs go up, as utility costs go up, as maintenance on those wonderful yards, those beautiful lawns and gardens that everybody puts in on your homes there, go up, affordable, people who truly need assistance aren't going to be able to afford those. And that means either the properties deteriorate or worse, get abandoned. And when that happens, it's not going to be a year or two from now. It's going to be 5, 6, 7 years from now when ADM has transferred the LOA over to the residents, and it will become their problem and their responsibility. And I know that's not what you want. I accept that. So as we talk, as Ms. Keene talks about CPC and other public-private, while I appreciate Mr. Donaldson's desire for ownership, I recognize that ownership is a challenge. It's certainly a challenge in a community such as Red Brook. And I know you made that effort even working with groups such as Habitat for Humanity, who raised those same concerns. I've spoken to them as well, and they've said the same thing. We would love to do a project there, but we don't see how it can ultimately be affordable. No matter, even if we give the home away, we don't see how it's ultimately affordable for someone who really needs the assistance. So as we look at the numbers to get to 113, I have some strong concerns over 19 units of single-family affordable. I note as well that you have 30 units of apartments identified. Well, we have 15 now. Obviously, you're thinking about 15 somewhere else.
Yes.
So,
Excuse me.
so I think that that's something that, again, the residents need to understand as we go forward, where those are going to go, how they're going to go, what types of clusters are we talking about? Because I know you're not talking about building another giant apartment building, because that's not going to happen. We've already discussed that, and that's not going to happen. And we've talked about not going over the 1175 base number, because that's not going to happen either. We're not reopening the permit for that. That's just not going to work. So let's talk about trying to find ways to create appropriate clusters of housing. Again, as you say, more likely attached housing, whether that's townhome, condominium, apartment, that type of living, that makes sense for Red Brook, that allows those people to be part of the community, but live in something that is, for the future, viable for them. So the other things that I want to go through just very simply are that while I appreciate there are certain obligations that developers have and timing that they can and can't do things, we need to think a little bit more about our residents. So I know at your meetings, it was reported to me that you indicated that earlier statements about roads on otherwise complete developments where the only issue is the affordables are not going to be paved, that that's not going to be the case anymore. Can you verify that publicly tonight?
Yeah, sure. Sorry, I cut you off. Yes, the open lots that are there will not hold up any finished landscaping or top coat. I did say, we had 2 sessions yesterday, and I don't recall if it was, I think it was the afternoon, the evening session when I said it, so the people that were here in the morning might not have heard this. We have slated right now, correct me if I'm wrong, about 4,000 linear feet to top coat. Every year we top coat. Those 2 neighborhoods with those abandoned lots, we did not program for this year, but I did make the commitment that we will do that in the first of next year. Not the first, meaning the first month, but that will be part of the next year's paving cycle. The last homes in those 2 neighborhoods, I believe, one might have been the end of 23 or one even in the beginning of 24. And we always do typically like to give 12 to 18 months or so, just for settlement wise. You guys can see the patches in there. And I did tell people there's still a few potholes, those types of things from construction. And we just asked them to let us know, we'll repair those. But I did commit to paving those next year. And not to let, regardless of what's going on with those lots, not let that hold up the process.
Thank you. So I'm not going to go through all of the lengths that we can go through and talk about this. I want to echo again what was said, that I appreciate the residents coming out, speaking, coming out in a very informed and educational fashion. We learn a lot from you. We encourage you to come out. I only wish the room was this full on a regular basis. Strange as that may sound for some people, that's the best that we can do, because we learn from you. This group sitting up here, we can't be everywhere. We learn from you. And every time we learn, we make the planning process better for the next group. And that's the best that we can do. That's our job, is to make it better. So we've learned how our TRIVID bylaw affects affordable housing, and we've learned better. So I'm just going to echo what Mr. Hartman said with respect to new areas, developments, restrictions. I don't think it will come as any surprise to you to say that this board will be looking very critically at any new proposal, and under no circumstances will we allow it to even get close to 95% construction without all of the affordables being built. And I mean built, not in process, under suggestion, concept. I mean, and I don't mean foundations in the ground that can be walked away. I mean completed. So, again, to the extent that I know I'm speaking to you as a representative and you report back, I'm speaking to your superiors as well, so that no one is surprised when the next time you show up, the grilling you get will be a little bit more severe than it might have been otherwise. But we're doing this for the residents, the people sitting behind you, who can't do it. I appreciate your holding the meetings that you're holding. I appreciate your statement that you're going to hold more of them, especially about some of these areas such as wastewater. The board will be asking you to come and report back on that when those meetings are held, so we have an understanding as to what the residents are learning, and so that, again, those people who weren't able to attend or those others can hear it in a public forum as well. So with that, is there anything further that you wish to say to us?
I would just like to echo the sentiment to say thank you, everyone, for coming out. I agree with Steve, not just for these projects, but I'm a huge proponent of more involvement into our politics. So if you ever have time to come to additional meetings, please do so. But thank you to the board, to the staff, and to everyone coming out this evening.
Thank you very much. So, Mr. Hartman, what is left for this board to address?
So you would have to take action now on whether or not the clarification of what the unit count is.
Is that for us to do, or is that for council to do?
Again, that's your call. I mean, we can refer to council, something we did not discuss, but if you'd like to do that, we can do that.
Ms. Keene.
Chairman Bulletin, I've been listening to you and your eloquence in discussing this intersection between the MOU and the special permit. And I believe that's a legal question, and I know that Red Brook, the Trivet, belongs to this board. The Zoning Board of Appeals often has legal questions, and they have town council sitting right there. We have not been afforded town council to sit here and interpret now a legal question. You've been very eloquent as an attorney that sits on the board, but you are not in a position to be the attorney for the board, which you know, and you've just brought that up. So in many respects, I think that we don't have all of the information that we need in order to vote on that issue. I would like to see town council, and I would like to read town council's interpretation back in the entire history of this trivet.
Well, I will ask again, is that the favor of the board?
I would like to make a motion.
Mr. Donaldson.
I'd like to make a motion that the interpretation be done through council, and we go through the council's recommendations.
Okay. Do I have a second for that motion?
Yeah, you're recommending, it was a little hard for me to hear you, Carl.
I'm sorry, yes. I'm recommending that we
Town council.
Yeah.
do the town
I'll
council,
second
yes.
that.
Okay, we have a motion and a second. Any further discussion? Mr. Bennett.
It sounds like, Stephen, I respect your legal mind immensely, and I think you're probably very correct. And it seems to me, before the idea of bringing it to town council, is that whether we vote on it or not is moot. It's in the special permit. We can't dig back into a special permit that's been granted without opening it with a new public hearing.
I think the question is whether or not that is the case. I mean, again, the special permit says what it says. The MOUs say what they say. How they intersect is a matter of law in terms of what we can and cannot overturn. But nonetheless, it strikes me again, and again, I did the research as an attorney for myself, not for the board, and so that's my assessment, but I have no objection and actually support, and that's why I raised the issue about having an independent view, that being our town council, whose job it is to advise this board as to whether or not, when there are legal issues, and that's a legal issue. The legal issue is whether or not this board can vote to do anything differently, or what this board's scope of vote can be. Is that to vote to say we're accepting the additional units as agreed by ADM? Is it to say we're deciding that units are inclusive of 1175 or in addition to? Is it both? I'd like to get that answer from an independent body, an independent attorney as well.
I agree. I think that so that we don't open ourselves, the town, to future litigation by having made the wrong move here, I think seeking the advice of town council is absolutely required. I think I'm prepared to vote.
Okay, so we have a motion and a second. Any further discussion then? No, so all in favor of referring this matter to town council for an opinion, say aye. Aye.
Aye.
Okay, that is unanimous. So for everyone here, everyone watching, what we're going to do is we're going to refer the matter to town council and ask town council, based upon the documents, the special permit, the bylaw, the MOU, what the scope of this board's legal authority is, what we are allowed to say and not say, what we're allowed to vote on and not vote on. Because while we're a board that makes policy, policies must follow our laws. And we're not the body that made the law. Town meeting passed the law back in 2005, so we need to make sure that we're doing what we're supposed to do to follow that law. But any interpretations that we make, that we're allowed to make, we will certainly be making based in large part on what we heard here tonight. So again, your opinions are heard, your efforts are applauded, and they will be considered regardless. So I thank you all for that. Ms.
I'd
Keene.
like to just say one more thing. I want to make sure that everyone that's here today understands that what we're seeking legal counsel on is whether the 113 units are additive or inclusionary. We're not seeking town council's opinion on whether or not affordable housing should be built or how it should be built. That's already baked in. We do that. It's just that one question.
Right.
Could you make sure that everyone understands that?
Absolutely.
Okay.
So,
We're not,
so
we're
again,
not taking affordable housing away
No.
from Red Brook.
So
Okay.
the special permit very clearly, somehow I don't think it's going, the special permit very clearly says that it requires ADM to follow the inclusionary housing bylaw. If you look at the special permit, it's actually the inclusionary housing bylaw is referenced in paragraph 2, paragraph 3, and paragraph 10. It's very clear. The inclusionary housing bylaw is part of their obligation. How they accomplish that is left to them. That's also part of the special permit. It says that they have the right to choose whether it is ownership, affordable, single-family, multifamily. That's their obligation. So those are not things that we will be asking anyone to interpret. What we will be asking council to interpret is whether or not we can, whether or not the law has decided that that 113 units is included within or in addition to the 1175, or whether or not it is up to this board to decide as a policy matter which way that goes. So that's going to be, again, a legal determination from council, and that's what we're going to be asking council. Nothing more, but basically, as I said, what the scope of our authority is to make any decisions. So again, thank you all very much for that. We do have a little bit of business left over, so if you're going to leave, please do so quietly. Do not carry on conversations in the room, and please step a little bit away from the door because, as you've seen, the acoustics in this room are terrible, and the best place that we can hear everybody is unfortunately out in the hall. Thank you all.
Can we defer this discussion?
Well, actually, we are going to defer it. It's going to make it very easy. Next on our agenda was a discussion of the elderly housing bylaw. And Mr. Hartman, why don't you give us the update on where we stand on that?
So we talked about providing some flexibility in the bylaw, a couple different things on how we deal with elderly housing. The problem we have is our bylaw just says simply elderly housing, doesn't define it. Defines an elderly household as all residents 55 and older. So we had initially talked about providing some flexibility for people with children with disabilities or maybe a spouse who is not 55 and older. Steve and I had a phone call with town council. It's a far more complicated situation than I think either of us imagined. So at this point, town council is going to give me some examples of what they think are good elderly housing bylaws, look at those as models, and then come back at a future date with the board to look and see if there are some changes we can make to our bylaw. But again, I think initially you have a draft there. It just is a lot more complicated than we thought.
Again, as we talk about, there are some legalities in terms of what our language can be or can't be, and how we comply with both state and federal regulations in changing anything. So we want to make sure that with anything that this body proposes to town meeting as a change is fully compliant with the law. So again, we're going to hear from council on that. So I think, so the answer to that is we're deferring. Last item on our agenda is, is new business. I just like to try and use this section to announce upcoming meetings. So on July 17th, there's the next Master Plan Committee meeting, 6 p.m. here at Town Hall. Great Hall. The agenda for that is the consultants are going to provide some of the information that they gained from the kickoff meeting and give us some thoughts on further public engagement. The committee itself is also going to talk about public engagement, including holding committee meetings in other areas of town at different times, different dates, to try and get as many people to get an opportunity to offer their thoughts. So we encourage everyone to attend or Zoom in. Also, next Wednesday is the Cedarville Steering Committee meeting at 6 p.m., and that's at the Cedarville Fire Station. Mr. Donaldson, did you have something?
No, you answered my question. I was asking about Zoom. Thank you.
Any other announcements or new business? Seeing none, I'll entertain a motion.
A motion to adjourn?
Second.
All in favor? This meeting of the Planning Board is adjourned. Thank you all.
Recording stopped.